Hi, I'm Pia Chattopadhyay, and you're listening to the Friday edition of The Current. Still to come, a story of two British stepbrothers, one who found all the answers in radical Islam, and the other trying to answer how his brother ended up in prison. But first, the issue of an employer's responsibility to act when an employee does wrong on their own time after a grainy video from a hotel's elevator camera shames the NFL.
I made a huge mistake, and I want to own it. I want to say it in front of my teammates to tell you I made a huge mistake. To sit here today and, replay the things that, my mom raised me to be. I let her down. I let my wife down. I let my daughter down.
NFL running back Ray Rice, that was him speaking at a press conference in July after the release of a security camera video showing him drag his unconscious then-fiancée, now wife, Janae Rice, from an elevator. Rice received a 2-game suspension and was ordered to attend court-supervised counseling. Many critics protested at the light punishment, and those voices grew louder this week when a second video became public. A camera inside the elevator shows Rice smacking his girlfriend with such force, her head is knocked against the elevator wall and she drops unconscious. The NFL was forced to reevaluate and has now suspended Rice indefinitely. Baltimore Ravens owner Steve Bisciotti, whose team Rice played on, was asked by a Baltimore television news station why the penalty was so light in the first place.
The way it was described to us was that he had hit her with an open hand and that she had hit her head. We already knew that they had told the police that they had consumed an enormous amount of alcohol, like 2 bottles of hard liquor between 4 of them. So that's what I'm guilty of, I guess, Jane.
Do you regret that? That's what I'm asking, I think, is don't you regret at that time saying, boy, that looks bad?
Yes. But, again, do I feel, that's my fault because we love race, so we have a tendency to hear what we want to hear and see what we want to see.
Well, that selective seeing and hearing has led the NFL to announce it has hired ex-FBI Director Robert Mueller to review the league's investigation. The case is dramatic and high profile, but of course this is not the first time someone has lost their job because of behavior unrelated to work. And it does raise questions about the responsibilities employers have to address their employees' behavior. So to explore this issue, we are joined by 3 guests this morning. Barb McQuarrie is the Community Director of the Centre for Research and Education on Violence Against Women and Children at Western University in London, Ontario. She's doing research on the links between domestic violence and the workplace. Natalie MacDonald is an employment lawyer and the author of Extraordinary Damages in Canadian Employment Law. And Chris MacDonald is a business ethicist and director of the Jim Pattison Ethical Leadership Education and Research Program at Ryerson University. Chris and Natalie are both here with us in Toronto, and Barb is in London. Good morning to all 3 of you.
Good morning, Pia.
Chris MacDonald, let me begin with you. We will get into some of the bigger questions in a moment, but just as a gut check, I want to start with your response to the Ray Rice story.
Well, I think that the Ray Rice story clearly, it's an example of a famous and wealthy man committing a heinous, outrageous bit of activity, and it's shocking to all of us, I think. But I also think there's a sense in which, that kind of case, this kind of high-profile case, may pull our intuitions in a certain direction, and we need to be careful about thinking about exactly what our intuitions would be about the ethics of this sort of case if it were, a much lower-profile case and a less extreme violent crime.
Okay, we will talk about our reaction and what it means in other circumstances in a moment. But Natalie MacDonald, from a legal perspective, what are employers required to do in these types of circumstances?
Well, Pia, in these types of circumstances, the employer is obligated to investigate and adopt the principle of investigating, assessing the situation, and making a conclusion, IAC. And once the employer has made a conclusion, it's going to decide whether or not to terminate for just cause or just to terminate without cause, or perhaps provide a reprimand if warranted.
And when you look at the Ray Rice case, did they do their due diligence, the NFL?
I don't believe they did at this point, Pia, from what I understand through my understanding of the media reports I've read and seen to date. They have not. And the fact is they had, certainly evidence at the beginning of the elevator where, in fact, they knew domestic abuse had taken place, and they didn't investigate it further. They just gave him a 2-game suspension, which I think obviously was a huge issue for the world.
Barbara McQuarrie, beyond what the law requires in these kinds of cases, why should employers be responsible for dealing with the private lives of their employees and what they do on their own time, if I can put it that way?
Well, I think that what employees do in their private time can, in this case certainly did, reflect on the reputation of the employer. And that's a reality. I mean, this was because of the very public nature of this man and his role, but it could be, in other circumstances, it could have been somebody who's in a helping profession and using abusive behavior just wouldn't be acceptable if he were a counselor, if he were a teacher, if he were in a role where he was dealing with people. I think it would also really harm the reputation of the employer. Okay,
beyond a reputational damage, which we'll get into in a moment with all three of you, why isn't this kind of matter, and I don't just want to talk about the Rice case, but why isn't this kind of matter simply left in the hands of the police, Barb?
Well, domestic violence has a huge impact on the workplace, and so we're just beginning to do research to understand this. We have a recent study come out of Vermont, and we're actually replicating that study in Canada, but we're in the very beginning stages, so I don't have data to report. But we know that almost a third of employees engaged in domestic violence report that they use workplace resources to harass, to stalk their partners. We know that almost 20% of them said that they caused or almost caused an accident while they're at work. We know that they're often absent from work, they're late from work, and 80% of them said that it negatively affected their job performance, the fact that they were engaged in domestic violence. So I think that we have tended to draw a line and say this is a private matter, and we're beginning to understand it's not a private matter.
It's a social matter.
It's a social matter, and it actually has financial implications for the workplace, productivity implications. It has an impact on the morale of co-workers and who know what's happening as well, and it's a safety issue.
Okay, Chris MacDonald, as an employer, what are the ethical considerations that an employer needs to weigh when responding to something like this? Not limited to domestic violence, but that or some other egregious behavior by one of its employees.
Right. I think clearly the employer needs to establish whether there is, for example, a risk to public safety, whether the person is that kind of risk, whether there's risk to consumers, customers, or to other employees. Clearly, in those kinds of cases, there can be cause to act. And obviously, companies don't need the advice to be told that if there's the likelihood of extreme public embarrassment, then that's something to look at too. But I think they want to look at not just is their gut offended, is there something that they don't like about this person. They need to ask whether there's something that actually impinges upon either the employee's ability to do their job or the ability of the company to carry out its mission.
And at what point does the company have an obligation to take action when an employee private misbehavior becomes public?
Well, I think that's really hard to say. I think clearly when there's substantial risk to anyone, an employer then, as a good corporate citizen, if you will, has an obligation to act. But you also don't want it to be the case that it may well be that what you need to do is notify the proper authorities. It's not just a matter of taking the law into your own hands, as it were.
And I suppose it depends on who the company is obliged to act on for the shareholder, for the public.
Right. Well, all companies have both responsibilities, effectively. If they have shareholders, they have obligations to their shareholders, but every company has public responsibilities.
Okay. Natalie MacDonald, let me just ask this very obvious question, which is this really so complex? Isn't good policy, if an employee is involved in a criminal or an illegal or just a disgusting act like a domestic abuse, shouldn't they just be fired?
Well, morally, absolutely. Legally, it's not as easy, and I say that because the employer really does need to go through a process, and essentially the Ray Rice incident actually, I think, highlights the issue of off-duty misconduct. And the law is such that if there is a sufficient connection between the misconduct and the employer's interests, and if it's prejudicial to the employer's interests, then you can terminate for just cause. So there's been case law that actually has outlined that issue, and it focuses on the employer's reputational loss. One would think and one would hope that, for example, the CEO who was kicking a puppy, the employer has every right not to employ that person in the workplace. The issue is, of course, you have to look at it in the context and determine whether or not the punishment truly fits the crime.
Well, let's just talk about that case a little bit. That happened in Vancouver, a highly publicized case. A man caught on video kicking his dog while he and his dog were in the elevator. He's a CEO of a company. And in the end, he ended up resigning after a huge public outcry. What do you read into that case?
Well, first of all, what I read is today we live in a fishbowl where every action we take is scrutinized, captured instantly by iPhones, and disseminated by social media. So I think the employer has a very stringent duty, once that comes to their attention, to act quickly and sufficiently. And I think moral actions like this, kicking a defenseless puppy, an employer does not have to be affiliated with that type of person. Now, whether or not it's just cause to terminate employment is a different story, because there may be, I can't see that there would be, but there may be some context to this that intervening factors would suggest otherwise. But specifically, I think the employer is well within its rights to get rid of an employee like this. And in this case, though I don't know the actual facts, but I understand that as the employer, they probably put to him, either you can resign or we'll terminate your employment for just cause.
Chris, let me pick up on something that Natalie and I were talking about just a moment ago, which is this bar that the employers seem to have to meet, and why they shouldn't just be able to fire someone who has done something criminal or illegal or just absolutely egregious. Do we need some nuance, and if so, why?
Well, I think, clearly, as Natalie says, you legally can do it. Whether it's always the best thing or not is less clear. An employment situation is a situation where I agree to hire you to do some work in return for some money, and if you continue doing the work, then at least on the face of it, you should, barring some public safety issue or some risk to the mission of the company, then you should probably should keep employing that person. And I think you also want to think about situations in which, someone like Ray Rice loses his job. That's not, he's a wealthy guy. But for a lot of people, the loss of a job might actually be a destabilizing factor, and you might not be making things better. You may be making things worse for that, not just for that person, but for their entire family.
I agree with that. In cases of domestic violence in particular, I think that employers have an opportunity to be a positive influence. They can certainly mandate treatment. And again, we know from research that men who have actually been convicted of domestic violence, in retrospect, say that their employer could, addressing the issue with them, would have been something they'd have listened to. I think that we're beginning to understand that domestic violence does come into the workplace, sometimes in subtle ways, sometimes in obvious ways. And we're beginning to understand that we have responsibilities, but these responsibilities need to be laid out in policies. I don't think employees should be surprised by the fact that all of a sudden the workplace there's going to be consequences for domestic violence. So, and the one thing that we haven't seen in the cases we've talked about is a policy. And so I think that that's really an important step to be taken.
Barb McQuarrie, another aspect of this, and again, just pointing to the Ray Rice example, but not explicitly using that, but his wife, Janae Rice, has really blamed the media now for what has happened. And so how do we take into consideration in the workplace the desires of the victims in these kinds of cases?
Well, I think the Ray Rice case is an exception because he's such a public figure, and I think that you have to expect when you're a public figure that your life is going to be somewhat on display. We've mentioned the fishbowl before, but that's really true for a sports fan. I think for the average person, confidentiality to the extent possible is really important to consider. And again, I think in cases of domestic violence in the workplace, absolute confidentiality often isn't possible in order to ensure safety. The way that we can work towards safety is by sharing information. But anytime we share information, we have to ask who needs to know and why do they need to know. And so it's not like we have to put out a bulletin to every employee in the workplace that this person is abusive or this employee is experiencing domestic violence. We have to do that in the context of a safety plan, and it should be, I think, these decisions about what information is shared is best made in collaboration with the employee, with our goal being safety.
Okay, Chris MacDonald, I want to pivot a bit. I mean, we've talked about serious offenses, but more often people get into trouble at work for so-called victimless crimes. Misdemeanors are just inappropriate behavior. Mm-hmm. Where does the employee's right to a private life in those kinds of situations fit in?
Well, I think that we need to take that very seriously. I mean, I think we need to worry about the extent to which our professional lives start intruding. I mean, we live in a fishbowl, not just in the Twitter sphere sense that an avalanche of tweets can sort of ruin your life, but that we increasingly live in a fishbowl with regard to our employers. We have smartphones that where many of us are subject to work email and other intrusions from our work life, for every waking hour. And so I think we need to think seriously about whether the extent to which an employer should be monitoring and acting. I mean, you can imagine all kinds of situations where an employer would see an employee in the park or walking down the street or in some other aspect of their private lives, and it's not clear that they always need to be policing that.
Well, I'm thinking of another high-profile case, but the Donald Sterling case in the NBA, who was caught making racist comments. Nothing illegal about that.
Yeah. Nothing illegal, just antiquated, morally repugnant attitudes that are kind of inconsistent with certainly inconsistent with the mission of the NBA and the sense in which it's both a company with an outward face, but also in a sense a club of wealthy individuals who own teams who just do not want and not for good reasons can't be associated with those kinds of attitudes. But
I mean, in the less public ones, I mean, is there there doesn't seem to be as much pressure perhaps when someone has a misdemeanor as compared to these very public ones?
Yeah, sure. I mean, sort of by definition, the stuff that isn't so high profile, we don't pay as much attention to it. I mean, but you think about the hard cases would be things like, one of your salespeople has regressive racist attitudes, and it doesn't affect his performance maybe, but still makes it an awfully awkward kind of person to be around. You can imagine lots of reasons related to your own leadership and team building where you'd want to at least seriously think about limiting that person's exposure to the rest of your team.
But if that comes to the employer's attention, then the employer has to investigate that situation, right? Because that could lead to
Do they legally have to investigate?
They certainly do. If an employee raises that as a concern, it's a poisoned work environment. Here we have an environment of discrimination, and it's being disseminated through this individual.
Okay, but the word investigation is kind of loosey-goosey. I mean, if I go to my boss and say, hey, the guy next to me saying some really racist things, about me or about other people, what is that employer's obligation? What does investigate mean?
Oh, that's a great question, Pia. Absolutely. And in fact, if the employer does not investigate, the cases are coming out fast and furious at the moment for extraordinary damages against the employer. So what does it mean to investigate? It means this. You must take the person's complaint seriously and understand all the particulars around it. You must give the individual who's being investigated an opportunity to actually respond to these allegations. You must, in fact, find impartial witnesses to this and look at all the evidence by at the same time communicating that to the person so that they know their complaint is being investigated, and then you must conclude the investigation and reach a decision. And you need to do it promptly and efficiently and as confidentially as possible.
Okay, and how do you ensure that there are checks and balances so that workers are given a chance, not only that workers are given a chance to defend themselves, but employers, where do they come into this?
I'm sorry, Pia, you mean employers?
I mean, if someone comes up with false allegations and the employer still has to investigate all of these things, has to go through the due diligence.
Absolutely.
Okay, Barb McQuarrie, how do you ensure that there are checks and balances so that workers are given a chance to defend themselves? If I, say the guy next to me has done something, where are the checks and balances on that?
It's in the process of investigation, and so I'm not an investigation expert, but you never take someone at their word. You look for corroborating evidence. You look for what do other co-workers know about the situation. Okay. You look for witnesses.
Okay, you talked about having policy and a good policy, Barb McQuarrie. What's an example of a good policy that an employer has established to deal with situations of egregious behavior?
I was specifically talking about having a policy as it relates to domestic violence in the workplace. So the American Bar Association has actually just come out with a model policy that it's recommending. And so the policy shouldn't deal just with employees using abusive behavior, but also employees who might be experiencing domestic violence. So the policy should include definitions. It should lay out expectations for employees' behaviors. It should let people know who do they go to in the workplace to discuss their concerns. There should definitely be a provision for safety planning, and then there should be a provision for accommodations that are needed to ensure safety, and that could be, if you're talking about a victim of domestic violence, a flexible schedule, leave, paid or unpaid. If you're talking about an employee that's using abusive behavior, it's mandatory treatment. But that is, again, after a process of investigation and establishing what's really happening. But sometimes these situations come to light very suddenly. And sometimes it's an incident of violence that actually lets us know that something has happened. And we don't want to be in the situation that the NFL was and trying to respond on the spot. We want to have thought out, what is our position on this? What steps do we have to take?
We just have about a minute left. Natalie and MacDonald, let me ask you, what kinds of issues arise for employers? Because there's a different situation. And what kinds of issues arise when an employee is exonerated of charge? Charged, exonerated, cleared. Does that automatically mean that the individual should be allowed to continue to work at its workplace?
It would depend, Pia. It would depend very much on the circumstances at play. I mean, if an employee is exonerated, why shouldn't they continue to work in the workplace? If the employee if there has been found insufficient evidence, but there have been other issues that have arisen, you may wish to send that employee to sensitivity training, for example, if you find that. Or if you're still not sure, you could actually mandate sensitivity training for the entire workplace because it's an important issue in any event. But just to be clear, employers must have a policy on workplace violence and harassment. Bill 168 mandates it. So now I think what Barb's talking about is expanding it into domestic abuse, which is something that the employer can only do if it comes to their attention. But a policy could be in place for that reason.
Okay, I want to thank all three. We'll just have to end it there, Barb. I'm sorry we're out of time, but I want to thank all three of you. Appreciate it. Interesting conversation this morning. Thank you.
Thank you.
Thank you.
Barb McQuarrie is the Community Director of the Centre for Research and Education on Violence Against Women and Children at Western University in London, Ontario. Natalie MacDonald is an employment lawyer, and Chris MacDonald, no relation, is the Director of the Jim Pattison Ethical Leadership Education and Research Program at Ryerson University. Both MacDonalds were here with us in our Toronto studio. Well, we do want to know your opinion on this. What responsibility does an employer have for those after-hour behaviors of their employees? You can tweet us at The Current CBC, post on our Facebook page, email us.